Hello. Sorry for the sun behind me, but what are you going to do? I can't move it. I guess I could move the car, but I'm not going to. So, um, two quick points. Number one, too dumb for lawyer. I found the case that I was referring to. It was Hyen, the South Carolina. And he then went on to, and I took screenshots and I posted it in Discord so you could see it there. He then went on to assert that Hyen versus South Carolina was about qualified immunity. Hyen v. South Carolina was not about qualified immunity. I got two things wrong. I got the state wrong. I thought it might be Georgia, but I knew I wasn't clear on that. The other thing I got wrong was that I thought it was meth when it was cocaine, because those South Carolina boys are classier than the Georgia boys, I guess. I don't know. So in Hyen, whatever, you get the point. The Supreme Court found that a mistake of fact gives reasonable suspicion to justify the stop, to justify the seizure under the Fourth Amendment of the car, the occupants, etc. It was a motion to suppress. It was not a motion for, or it was not a 1983 lawsuit where the officer was asserting qualified immunity. It was a motion to suppress. But even if it was, even if too dumb for lawyer was right that it was a issue of qualified immunity, if there is reasonable suspicion, then there is reasonable suspicion. It's not the kind of thing where you might have a reasonable suspicion in terms of the seizure being okay for the suppression of the evidence, but not reasonable suspicion in terms of the seizure being okay as far as an unlawful arrest or something along those lines. If you have reasonable suspicion, you have reasonable suspicion. The other thing is that if you actually look at Georgia law, they've had a couple cases come out after Hyen. I think one is Abercrombie. I think that's the big one. And that was in like 2017. They had another one in 2018, Hayes or something like that. Abercrombie v. State. The other one just relies on Abercrombie v. State. And it builds on it. It understands and incorporates that, yes, it is reasonable suspicion. In Abercrombie, the officer had an unreasonable mistake of fact. And so Abercrombie said, yes, if there is a reasonable mistake, or excuse me, an unreasonable mistake of law. The officer thought that you had to have a rear view mirror, the center rear view mirror in a particular method or fashion or something, and you couldn't just have two of the side view mirrors. And the court found that was an unreasonable mistake of law. So it is a Georgia thing. It is a U.S. thing. It is a thing. A good faith, reasonable mistake of law by an officer does not disqualify a stop from having reasonable suspicion. It doesn't disqualify the officer from having reasonable suspicion based on that mistake of law. I really butchered that sentence, but I think you understand what I'm talking about. So that addresses his weird assertion that Hyen was somehow having to do with qualified immunity, and I don't know, he said Bing bitch, like he made a point. I don't know. I don't get it, but he's a retard, so what are you going to do? The second point that he raised in a different comment was that he wants me to cite a Supreme Court case saying that making a U-turn in front of a checkpoint grants reasonable suspicion. And he's the one asserting that it doesn't grant reasonable suspicion. Now, I don't know of any case law, any Supreme Court case law that's directly on point, but you got to understand that the Supreme Court deals with a very limited selection of cases, and typically when you're going in against a state on a state charge, you're going to be dealing with state law. The states will interpret Supreme Court decisions, and they will. The point of a Supreme Court decision isn't for it to be directly on point for everything. It's to give attorneys, like real attorneys, not internet pretend lawyers, an idea of how the Supreme Court thinks on an issue. And so you're supposed to be able to extrapolate from the holding out to other things. And the lower courts will typically do that. Federal courts will deal with federal issues, federal questions on it, but state courts deal with a lot of constitutional issues, and they also have to balance in their own constitutions on it, et cetera, et cetera. So you always want to look to state law on these things first. But to answer his point, there is a U.S. Supreme Court case that is very relevant, and the language in it should be revealing, and we've talked about it innumerable times, and that's Illinois v. Wardlow. Let me set out the basic fact pattern again for you in case you haven't been paying attention, like Too Dumb for Lawyer typically is not capable of doing. A man is standing at the corner of a building in an area that's known to be high crime. Cops roll in. A caravan of cops roll into the area. The guy sees the cops see the guy, and the guy takes off running. Reasonable suspicion. The Supreme Court held in Illinois v. Wardlow that nervous and evasive behavior is evidence enough to give reasonable suspicion. You could develop reasonable suspicion off nervousness and evasive behavior. Flipping a U-turn right before a checkpoint, there you go. Quaderat demonstratum. You don't have to do anything illegal. You don't have to have some illegal action plus evading it. You got to remember, the guy in Illinois v. Wardlow did nothing but run. That's it. He saw the cops, ran. Reasonable suspicion. I don't know what more you need. Thanks for watching. Have a great day.